The topic today is being presented by Ben Symons. It will be on 18C of the Racial Discrimination Act. If you don't know it, it's been in the news a lot lately. It deals with hate speech, but the topic overall will commence with freedom of speech, and then we'll tailor off into, or Ben will tailor off into hate speech. Ben asked me to introduce this just by way of discussing the theoretical underpinnings of freedom of speech, and I'll just spend about 5 minutes introducing it in that way, and then Ben can get more specific and talk about the Australian context. But as far as the theoretical underpinnings go, if you have a look at the paper that Ben distributed, there are three generally, and the first is the importance of discovering the truth. So if you read the paper, you have a look at some of the quotations there by John Stuart Mill. He was a person associated with utilitarianism. There were other natural rights philosophers that came before Mill who talked about the rights of people, like Locke. Locke thought that once you entered a society, you left certain of your rights behind, but you kept some of them. He defined those rights in a negative sense, freedom from government interference. There was also Rousseau, who was famous for being the progenitor of the French Constitution in 1789. Rousseau believed that you retained none of your natural rights once you entered the social contract with society. But Mill was at the other end of the spectrum. Mill believed that you retained everything, and that's why his famous treatise was called On Liberty. So liberty was foremost in Mill's thoughts. So coming from that influenced a lot of modern day thinkers. And for example, in American First Amendment jurisprudence, we often hear the aphorism that sunlight is the best disinfectant. So notwithstanding how unpopular speech might be, the idea is that once you get it out there and contest even offensive speech, that ultimately the truth will be borne out. That was most famously, I think, captured in a decision by Oliver Wendell Holmes, said to be the most famous dissent in American history, Supreme Court history. Holmes was a dissenting judge in a case called Abrahams in 1919, in which some communists were prosecuted under the Sedition Act of 1919 for distributing pamphlets during the First World War, complaining about the war effort. Now, they were convicted, notwithstanding their right to express their opinion. There was no immediate danger of sedition or anything like that, but nevertheless, based on their views expressed in pamphlets, they were found guilty of a crime. That would never happen under modern day jurisprudence. That's gone beyond that. So Holmes, I think, was the fork in the road and the turning point as far as that goes. So his famous line out of that dissent was the marketplace of ideas, and his idea was similar to that of Mill's, that once you get ideas out there and speech out there, then those sorts of contests result in the truth being uncovered. But the question is, does free speech actually guarantee the discovery of truth? That's the question. There are some examples in history, of course, where free speech has been suppressed at the expense of the truth. One thinks of Giordano Bruno, who was burnt at the stake in the year 1600 for his belief that, or for his understanding of Copernican system of cosmology, that the Earth wasn't the centre of the universe. In fact, we revolved around the sun. And Galileo, as you know, a few years later was forced to abjure his beliefs on the same grounds, on pains of a similar fate to Giordano Bruno. So that's the first idea, the importance of discovery of truth. The second is citizens' participation in democracy, and that's the basis of freedom of speech in Australia. constitutional speech, I should qualify, because Ben will talk about the other basis in a moment. But constitutional speech is born out of the constitutionally prescribed guarantee that we have representative and responsible government in Australia, and the High Court held in 1992 that free speech was indispensable to those principles. The third, and I think one of the most interesting ones, and this is the basis of 18C in fact, or the rights of free speech under international conventions, is that free speech serves as an act of self-fulfilment, and the Universal Declaration of Human Rights 1948, created as it was after the experience of World War II, was grounded in the idea of human dignity, and this traces itself back to Immanuel Kant, who believed that the autonomy of the individual was central to the idea of rights and duties. At that stage in 1948, the idea of natural rights had actually fallen by the wayside. Natural rights as they existed in Magna Carta 1215 gave way to parliamentary supremacy. The French experience in 1789, the Declaration of the Rights of Man, that was replaced by the Constitution of the Third French Republic. It didn't mention rights at all. So really 1948 represented a revival of theory of natural rights. And just on that, the irony of the French Declaration of the Rights of Man and Citizen, Article 11 actually said that the most fundamental of all of these rights was the right of freedom of expression. In answer to the Declaration of the Rights of Man, there was a famous lady by the name of Olympe de Gouges. She wrote a treatise called Declaration of the Rights of Woman and Citizen. And her idea was these rights that have been identified in the French Constitution did not extend to female suffrage. So her point was that it didn't go quite far enough. And she was writing pamphlets at the time, probably the wrong time, because this is at the height of the Reign of Terror, critical of the National Assembly. So she suffered the same fate as all of the Girondins at that time. And on this day in 1793, she met her fate at the guillotine. But her famous last words were that if woman is able to climb the scaffold, then she's also able to climb the rostrum. So with that, Ben, I'll leave it in your capable hands.
Welcome to my presentation on freedom of speech and regulation of hate speech. It focuses mainly on Australia. So section 18C and 18D, you can see the main provisions there. It's unlawful for a person to do an act otherwise than in private if the act is reasonably likely in all the circumstances to offend, insult, humiliate, intimidate, or a person or a group of people based on their race or ethnic group. Then in section 18D, there's a defence. Section 18C doesn't render anything unlawful if it's done reasonably and in good faith in the performance of an artwork or in making or publishing something that is a fair and accurate report of a matter in the public interest or fair comment of a matter in the public interest. So what is the Australian model? The Australian model is basically the antithesis of what Tom was describing before, the US model of the marketplace of ideas. The Australian model is the other end of the spectrum. It's more aligned with the European countries. Basically, we have more protections against more encroachments upon free speech, and more protections against acts and speech that are racially prejudicial. In Eatock and Bolt, Justice Bromberg said that sections 18C and 18D were seeking to balance two competing rights: the right of freedom of expression and the right to be free from racial prejudice. And in Justice Lee and Brofo said that neither of these rights is unbending, and when looking at section 18C and 18D, you're essentially involved in a balancing exercise of balancing those two rights, the right of freedom of expression and the right to be free from racial prejudice. And Justice Bromberg also considered in ETOC that at the heart of these provisions was trying to secure a society free of racial prejudice and intolerance, and protecting equality and the dignity of all human beings. What are these statements of principle in relation to 18C? The words offend, insult, humiliate and intimidate are directed to speech or behaviour that has profound or serious consequences, not mere slights. Freedom of expression is not limited to free speech, which is polite or inoffensive, but there is no requirement in Section 18C for the speech to communicate hatred. There is no requirement for hatred. In Tobin and Jones, Justice Clarke said 18C was aimed to prevent public expressions of offensive racist behaviour that might lead to racial hatred. So 18C is directed to speech that is something less than hatred, something less than expressing racial hatred. What are the principles that come into play in interpreting 18D? Well, the defendant has to establish the defence on the balance of probabilities. There is a requirement to act reasonably and in good faith, and this has two requirements. The first is to look at the subjective motive of the statement maker and consider subjectively whether they're acting reasonably and in good faith. And then there's an objective test, looking at the speech of the statement maker objectively and making an assessment of whether their behaviour is destructive of the overall objectives of the act. And Justice Bromberg considered in ETOC and Bolt that in raising an 18D defence, the statement maker had to show that they exercised prudence, caution and diligence to minimise the potential harm of their speech. Okay, the case of Brofo and Human Rights and Equality Commission. This concerned a cartoon strip that appeared in the West Australian newspaper in I think it was around 2000, and the cartoon strip concerned an Aboriginal elder called Yagan. Yagan was murdered in 1833 by white settlers. His head was put in a smoking tree and transported back to England. It was displayed at the Royal Institute in Liverpool and then buried in Everton Cemetery. In 1990, the members of the Nyungar community, who were his ancestors, sought permission from the British government to repatriate his head, and there was a big public fight about who should bring his head back. There were different warring factions, there were different tribes. Some of them sued each other in the Supreme Court of Western Australia, trying to stop other people from repatriating his head, and this led to the publication of this cartoon strip. There were a number of editorials in the Western Australian discussing these matters, and this was towards the end. The end of this matter, this cartoon strip was published, and one of the Nyungar ancestors took offence at the cartoon strip. What we see in the cartoon strip is it's a satirical look at the events that took place, and we've got an Aboriginal elder discussing or telling, if you like, a Dreamtime story to a group of Koori kids, and among other things, the cartoon suggests that says that some of the warring tribes are mixed race, some of the people are mixed race, and some of them have other motives. They're not motivated by spiritual beliefs. They're motivated by a taxpayer-funded trip to England. That was their motivation for repatriating Yagan's head. And in the final panel, we see a cardboard box with Yagan's head pining to go back to England.
For a warm beer.
Yeah, for a warm beer. It says, "Crikey, give me a warm beer in a quiet pommy pub any day." So somebody, or Mr. Brofo, came along and challenged this under Section 18C, and it was ultimately held that the newspaper was able to establish the Section 18D defence. The Human Rights and Equality, this was heard in the Human Rights and Equality Commission, and they considered that overall the West Australian newspapers' coverage of these events was balanced and reasonable, and in all the circumstances, the cartoon was fair comment on a matter in the public interest. So in that case, the newspaper established the Section 18D defence. The next case I'm going to talk about is Creek and Cairns Post. This concerned the photo. Hang on, I'm going to have to just briefly find the photo. This concerned a photo that was published in the Cairns Post, 31 July 1997, and the story was about a 2-year-old girl that had been taken from a white couple and put in the care of an Aboriginal relative. The child's natural mother passed away when she was very young, and the newspaper article was commenting on the Stolen Generation report and the fact that this Aboriginal child was taken from her white parents and put in the care of an Aboriginal relative. Okay, so in the top left-hand corner, there's the white couple, and we can see in the top right-hand corner that's the Aboriginal child, 2-year-old Aboriginal child, and the complainant is featured in this photo here. She complained that this photo depicted her as a primitive bush Aborigine, but the child wouldn't be cared for, and this was the usual way in which she lived. At the trial, it turned out the newspaper had selected this photo because it was the only photo of the applicant they had, and Justice Keifel found that to this particular individual the photo was offensive, but the photo had nothing to do with race. So again, there was no infringement of Section 18C. Yeah. Okay, the case of Tobin and Jones. Tobin and Jones. Robert, I've got a picture in there of Dr. Tobin, and he's pictured with the president of Iran. But Dr. Tobin was the director of something called the Adelaide Institute, and it published statements on the internet that were that amounted to Holocaust denial. They doubted the Holocaust occurred. They claimed that 800,000 people rather than 4 million people died in Auschwitz. They questioned whether there were gas chambers in Auschwitz, and they said that Jewish people exaggerated the Holocaust for their own financial gain. And yeah, Justice Carr had no trouble finding that those statements infringed Section 18C. And what came out of that case, probably the most important thing that came out of the case was 18C was aimed at preventing expressions that might lead to racial hatred. There was no requirement for hatred in Section 18C, and no requirement to read hatred into 18C, and something less than hatred can infringe Section 18C. The final case, the second last case is Eatock and Bolt, and this is probably the case that has got most attention. Andrew Bolt published 2 articles in 2009 in the Herald Sun newspaper in Victoria, and he commented on 18 figures in public life, and those 18 figures were Aboriginal people. They were people that both sides accepted had an Aboriginal ethnic background, and they were fair-skinned. What came out at the trial is that some of Mr. Bolt's comments were factually inaccurate, and that created a problem for him because that made it hard to establish a Section 18D defence. But Justice Bromberg ultimately found that his comments were offensive because they suggested that these people were identifying as Aborigines in pursuit of their own political and career gains, and in his view on the evidence that that wasn't the case. With one of them, with Jeff Clarke. Jeff Clarke had been raised in Warrnambool. He was fair-skinned, but he was raised by an Aboriginal mother in Warrnambool, and he was subject to racist abuse at school. The evidence was broadly that he'd always identified as being Aboriginal, and I guess those weren't fair comments. But in terms of the 18D defence, the problem Mr. Bolt faced was that he had made a number of factual mistakes, and that made it that made it difficult for him to rely on the 18D defence. That is what can be taken from that case. And the final case is Pryor and the Queensland University of Technology. In that case, concerned three students who went into a computer lab in the Queensland University of Technology, and they were asked to leave because they weren't Indigenous. And they went and posted comments on the QUT Stalker Space Facebook website. Mr. Wood said, just got kicked out of the segregated Indigenous computer room. QUT stopping segregation with segregation. The judge there found no breach of Section 18C. The comments were directed to QUT and were against racial discrimination, so there was no problem there. The second student, Mr. Powell, posted comments. I wonder where the white supremacist computer lab is, and the judge there held that, under 18C there was no offence caused by that comment. It wasn't sufficient for anyone to be insulted, offended, intimidated by that comment. And the final student, there were racist slurs attributed to someone with the name Mr. Thwaites, but he denied making them. He said somebody else published those comments under his name, and there was no evidence offered to prove that he made those posts, and so that claim was dismissed. So there was no infringement of Section 18C in that case either. Attacks on religion aren't specifically covered in Section 18C. If they are attacks on an ethnic group, you could say potentially that is an attack on a religion, but that is something that is not covered in Section 18C. But it is covered in the Racial and Religious Intolerances Act in Victoria, a 2001 Act, and that is basically the same as 18C, except it makes unlawful any incitement of hatred or severe contempt or ridicule for someone on the basis of their religion. It's basically drafted exactly along the same lines as Section 18C. And I had a comment there. Most things are published on the internet these days. Someone downloading that in Victoria could take action, and if someone in Victoria can download potentially offensive content, they can take action, along the lines of 18C. What are the proposed amendments to 18C? There was a report in February 2017 this year, and it basically recommended codifying the case law that we've had on 18C. It suggested maybe changing the words insult, offend and humiliate with the word harass, and putting the words profound and serious consequences into Section 18C. A couple of slides on the US approach to regulating hate speech. The guiding principle here is the marketplace of ideas that Tom was talking about. Essentially, there are three types of speech that are prescribed or where an encroachment on freedom of speech is permitted. One is obscenity, the second is defamation, and the third is speech that gives rise to imminent lawless action, and hate speech comes within the third of those. The leading case of that is Brandenburg in Ohio, and that was a US Supreme Court case back in 1969 that concerned a television production that showed members of the Ku Klux Klan in their traditional dress and making racist comments. the court there held that making racist comments in an abstract sense is not prohibited under the First Amendment. People are entitled to express themselves in an abstract way, even if it means using racist comments under the First Amendment. It's only where those comments may lead to imminent violence that they are prohibited. And following on from that, that basically draws on the marketplace of ideas doctrine that in general you can say what you want, and it almost presumes people are rational. You can express yourself as freely as you want, and I guess in the marketplace of ideas, the truth or the best ideas will win out, and that is the guiding principle in US jurisprudence on free speech. The approach in the UK has been to use public order acts to challenge hate speech, and something less than violence is generally actionable under the public order acts. In 1936, the UK modified their statutes so that speech that was likely to lead to violence or had the mere intent of violence was unlawful under the Public Order Act, and supposedly this assisted in preventing the rise of fascism in the UK. That was around the time of the rise of the Nazis in Germany. The UK has a number of different statutes that they use to regulate hate speech. They tend to use the Public Order Acts, and some of the articles I read suggested prosecutors weren't being tough enough. But yeah, that is how the UK has chosen to regulate hate speech. And that's it.